Gerald Newman, and I'm the director of the Human Rights Program here at Harvard Law School. And thank you for joining us, those in the room and those in the online audience, in today's panel on deportation in international law and comparative perspective. It's a challenging subject to discuss at any time, and even more so today. But fortunately, the Human Rights Program is hosting a globe-spanning group of experts for an intensive workshop under the auspices of the International Law Association, and some of the leaders of this project are with me on this panel. Let me introduce them, and then I will be appropriately quiet and let them tell us about their important work. Second from the left is Professor Vasilka Sancin, who is a professor and head of the Department of International Law at the University of Ljubljana. She will start her judgeship with the European Court of Human Rights next month. She served from 2019 to 2022 as a member and vice chair of the UN Human Rights Committee, the monitoring body for the International Covenant on Civil and Political Rights. And she is the co-chair of the International Law Association's Committee on International Migration and International Law. To her right is Thibaut Fleury Graff, a professor of international law at Paris Panthéon-Assas University in France. He is also an international expert for the United Nations High Commissioner for Refugees and the co-chair, the other co-chair of the ILA Committee on International Migration and International Law, and also of their RefWar project. Immediately to my left, Sanzhuan Guo is a visiting fellow at Harvard Law School Human Rights Program, and an associate professor from Flinders University in Australia. She's an accredited immigration law specialist in Australia and the rapporteur of the International Law Association Committee on International Migration and International Law. It's beginning to sound familiar. She's a qualified lawyer in China, the United States, and Australia. She was the co-convener of the Academy of the Social Sciences in Australia workshop project on a critical lens on mass deportation of non-citizens, law, crimes, and technology. And all the way to the left, Marinella Marmo is a professor of criminology at Flinders University, Australia. She's a leading scholar on deportation, human mobility, and modern slavery. Her research has been cited by academics and senior policymakers worldwide. She's the chief investigator of the Australian Research Council's Discovery Project on criminal deportation and co-convener of the workshop project on a critical lens on mass deportation of non-citizens, law, crime, and technology, aforementioned. Finally, I'd like to thank our co-sponsors, the Program on Law and Society in the Muslim World, and the FXB Center for Health and Human Rights here at Harvard. Without more preliminaries, please, Professor Sancin.
Thank you very much, and it's a great pleasure to be here in such a distinguished company, but also at a very important point in time, as our moderator has already mentioned. And I would like also to thank all the organizers, sponsors of this event, and also all the audience who took the time to come and engage in discussion with us. So we were asked to be very short, which I will try to do, and I wish to present to you a little bit the practice of the United Nations Human Rights Committee, where I served recently. And just in order to kind of situate this committee, there are 10 currently UN human rights treaty bodies established on the basis of relevant conventions, and the UN Human Rights Committee is one of those established on the basis of the International Covenant on Civil and Political Rights. It is composed of individuals who serve in their personal capacity as experts, independently from any governments. They are elected from 174 currently states parties to the ICCPR, while there are currently 116 states parties to the optional protocol to the International Covenant on Civil and Political Rights, meaning that these 116 states also accept the competence of the Human Rights Committee to decide on individual complaints. So these treaty bodies, including the Human Rights Committee, are established to monitor state parties' compliance with these treaties. Periodic reviews is one of the, let's say, most general function of these treaty bodies. These reviews take place periodically. The committees have recently, 2 years ago, decided that they will review states parties every 8 years, and that they will continue with these reviews even in cases where states do not come to Geneva for the dialogue, they don't appear for the review, in order to have some, universal, let's say, approach towards these periodic reviews. Those who have the competence, and towards those states that have accepted this competence, also review or decide on individual complaints submitted by authors to these committees, and adopt views which are not binding in the sense of judgment of regional human rights courts. Nevertheless, they should carry great authority, if not for other reasons, because the states have accepted to comply with the optional protocol. It's a bona fide obligation of all states parties. Committees also adopt general recommendations and general comments. The Human Rights Committee adopts general comments in which it clarifies obligations of states under the ICCPR and provides some authoritative guidance on how these treaties are to be implemented in practice. Domestic courts, regional courts, but also International Court of Justice have recognized the great weight that should be ascribed to these general comments when deciding on any potential violations of rights contained in the ICCPR. There is also a possibility of interstate communications to be brought to the United Nations Human Rights Committee. However, this option has never been used so far in practice. There recently has been some emerging, let's say, practice because there were 3 cases brought to the Committee on Elimination of Racial Discrimination. Now, this is perhaps an interesting venue to consider for the future, given that we see more and more so-called erga omnes partes cases being brought to the International Court of Justice, and there would be kind of a similar opportunity before the treaty bodies, including the UN Human Rights Committee. So generally, what these treaty bodies have said is that state sovereignty, when it comes to expelling non-nationals, is not absolute, but is actually balanced against international human rights standards and obligations that protect fundamental rights of individuals, regardless of their nationality or immigration status. So the Human Rights Committee, as I said, is the body that reviews and considers individual communications brought by individuals to it on the basis of the International Covenant on Civil and Political Rights, which does not contain any explicit substantive standards to be respected by states in situation of expulsion of aliens, nor specific provisions prohibiting certain types of expulsions. In fact, the only ICCPR provision containing a reference to aliens is to be found in Article 13, which was modeled on the basis of Article 32 2, paragraphs 1 and 2 of the 1951 Geneva Refugee Convention. So this is just for the comparison. You see there is a huge similarity among the language used, and in fact what this Article 30 brings are some procedural safeguards. But on the basis of the practice also by the UN Human Rights Committee and then the states parties domestically when implementing the covenant, the International Law Commission, when in 2014, it drafted Article 26 and identified what could be these procedural safeguards in cases of deportations, identified these 6, let's say, procedural rights on the basis of Article 13 and other relevant articles of the Covenant implemented as per also authoritative guidance by the general comments of the committee and concluding observations. Now, although there is no explicit reference to aliens in the Covenant as such, there is quite a significant practice of the committee emphasizing that the Covenant does provide guarantees for a range of rights relevant for the expulsion of aliens. And you have here a list of those rights that are also regularly argued in cases before the UN Human Rights Committee. The committee has adopted several general comments explaining the obligations of states under the Covenant. The most relevant for our topic is, of course, the general comment number 15 on the position of aliens under the Covenant. However, in several other general comments that you have here listed, the committee did refer to what are certain obligations that relate also to the rights of aliens that are subject to deportations. In concluding observations, this is the document that the committee adopts after periodically reviewing a state party, we can observe that recommendations touching upon the treatment of aliens, including the situations of deportations, has become a mainstream feature in periodic reviews. And I think it's important to highlight that these documents are all word limited. So there is certain word limit, and the committees, they always have to decide which issues to include and which perhaps to, let's say, sacrifice because the others are more important. So the fact that deportation issues are regularly featuring in the concluding observations is already an important signal of the importance of this topic. In individual communications, from practical perspective, it is very important to note that the committee has been very, let's say, generous in granting requests for interim measures in cases of deportations. And this is of significant practical value because when the committee issues an interim measure to stay the removal of an alien, it means that the state party is expected to comply. It is expected as a party to the protocol to legally comply with this obligation. And given the huge backlog of cases before the Human Rights Committee, it means that this person can be protected by these interim measures for 5, maybe up to 10 years. So it's a very significant practical measure that is becoming more and more of interest also to the lawyers who are working with authors who are finding themselves in these situations. Here you have also some other rights that have been argued in such cases before the Human Rights Committee, including the right to return to the country of his own, as the language of Article 12.4 provides for. But also we need to note that many communications are found inadmissible, mainly due to the non-exhaustion of domestic remedies, but also due to insufficient substantiation. And when one tries to identify criteria for deciding on inadmissibility based on insufficient substantiation, we find a rather inconsistent jurisprudence in that regard. So this was 9 minutes. I apologize for that. Thank you. I'm looking forward to our discussion.
Thank you. Professor Fleury Graff.
Thank you. Thank you very much for your invitation. That's I'm really glad and honored to be there. Thank you, Sandra, for having organized everything. So I will give you a really broad overview of deportation of aliens under French law and practice. So in 7 minutes, I have to say that it's quite challenging to present that to you. So let's start with the general framework and then some general tendencies as of today. So we have two main procedures, and I have included some flash codes. So if QR codes, so if you flash this code, you will have a direct access to the sources I'm mentioning, because sometimes it's quite challenging to get access to domestic law, etc. So if you go on this QR code, you will find the code de l'entrée et du séjour des étrangers et du droit d'asile, which is the French law on right to entry, right to stay, and asylum law for foreigners. So under this code, we have two main procedures. The first one is what we call l'obligation de quitter le territoire, which means the obligation to leave French territory. Can be somehow translated into removal order. And the other main procedure is expulsion. And the main difference between these two procedures is that the obligation de quitter le territoire is applied to people that are irregularly staying on the French territory. So either because their visa expired or because they are not more respecting the conditions to get a stay permit, then in that case they can be removed from the French territory. The expulsion procedure will apply to foreigners regularly staying on French territory, but with a threat to public order. So in that case, they could be deported mainly in their country of origin. It depends. I will turn then to the case of refugees, for example. This actually does not concern a lot of people. You have here some statistics, and once again, you have a QR code if you want to go to all the statistics that exist. So those are official statistics. According to which, as you can see, in 2024, so we had a little bit more than 20,000 people that was forcibly or that on a voluntary basis went back to their country of origin, whereas French authorities had adopted 140,000 decisions of removal. So, which means that the effective execution of this decision is very low, because it's actually very difficult to effectively deport people for many reasons that I will expose if there are any questions on that. But this is mainly one of the first important findings when you focus on the practice of France regarding the deportation of aliens. It is very difficult to effectively deport aliens, mainly because of a lack of cooperation from the country of origins. This is one of the main reasons. So there are two ways to force someone to leave the French territory. One is what we call voluntary basis, in which case the foreigner will have generally 1 month or a little bit more to leave the French territory on a voluntary basis, so on its own. And if such is not the case, then there is a possibility to force that person to leave French territory, in which case there is a possibility for French authority to pronounce an house arrest. I hope the translation is okay. In French, we would say assignation à résidence, which means that you are obliged to stay at home or in a certain region, and you have to go to a police station like twice a day to make sure that you are still in your home or in that region. And the other possibility is administrative detention. There is no time limit for house arrest. It can last for like sometimes years. Whereas for administrative detention, the maximum is 90 days. And then if you have not been deported during those 19 days, you have to be freed from detention. These two measures would apply also to, in the case of threat to public order, in the case of expulsion. So when someone is concerned by this procedure of expulsion, then there is a possibility for French authorities to adopt a decision on house arrest or administrative detention. Then, of course, there are some other procedures. The two main ones are the following one. There is a possibility of an administrative ban from the French territory, interdiction de retour sur le territoire français for 2 years maximum. So when someone has an obligation to leave the territory, then administrative authorities can decide to ban the foreigner to come back on French territory for a maximum of 2 years. And there is also, this is another measures in interdiction du territoire français, which could be translated as criminal deportation order. This is a criminal sentence. So when you are convicted for something, then the judicial judge, the criminal judge, can decide to add another sanction, which would be an interdiction du territoire français for 10 years maximum in that case. Of course, there are some guarantees of the rights of foreigners. Firstly, under international law, France is party to almost all the universal treaties on human rights, like the ICCPR, the Convention Against Torture. Of course, the international customary law will also apply, the principle of non-refoulement mainly. And we also have a lot of EU law implied in these procedures. There is a specific European directive, which is the return directive. So those are norms that EU member states have to respect. And for example, it means the obligation to adopt a decision on removal, to be able to have the right to contest the decision before a judge, to appeal, etc., etc. And the European Union Charter on Fundamental Rights, which is somehow the equivalent of the European Convention on Human Rights, with several rights at stake. Article 3 on the prohibition of torture, Article 8 on the right to private life and family life, and Article 13 on the right to an effective remedy if one of these rights has been violated. There are also some obligations under domestic law, and I would like to conclude on that. There used to be several protections against the obligation to leave French territory, but since last year, since a new law that has been adopted in January 2024, there is no more protection except for people aged under 18. So this is now the only protection that exists. French authorities cannot adopt any obligation to leave French territory for people under the age of 18. They can adopt obligation to leave French territory for other people. Of course, they will be able to contest the decision before a judge, and if this is an infringement to the right to family life, the obligation will be cancelled by the judge, but still it is no more a legislative protection, whereas before this new law, it was a legislative protection. And as to expulsion, there are different categories of foreigners. So the more the foreigner has strong link with France, the more French authority will have to demonstrate a real threat to public order or to national security or to France's fundamental interests to have the right to adopt a decision of expulsion. But to conclude on this point, a new tendency which is really a strong one, is that French authorities rely a lot on threats to public order to use urgent procedures. And according to these procedures, there is then no right for the alien concerned to contest the decision. And this is something that is really important nowadays, included for refugees, which are usually protected against expulsion, against deportation, at least toward their, to their home country. But still, in the recent years, we have seen a lot of deportation, including for refugees, including to their country of origin. Thank you.
Thank you. Professor Guo?
Thank you, Professor Newman, and I'm really grateful to be here, and thanks to the Human Rights Program, and thanks to Professor Newman, and for our event yesterday, including and today. We had a book project on deportation yesterday and whole day, and today we have this session. I just jump to my part, and I'm presenting on China today. And I grew up in China. I studied law in China, practiced law in China, but I never practiced immigration law in China because immigration law in China is generally not yet or not that popular area, or we don't have sufficient immigration law practice in China. However, I'm presenting on China, actually starting with to talk about the US. If you see the slides, I put my article there. That is the part of the project we did last year, 2024 February workshop on the deportation. And yeah, we start with the election of the US and then say what's China, because nowadays we talk about China-US competition all the time. Are we also competing in deportation area? So that's the general background, but today my presentation is really very short, very quick. Really just two parts is about the data to show what is the deportation statistic in China. Do we deport people, and how do we do it, and general legal structures a little bit. So everything here is actually written in my very recently published article. So if anything you want a detail reference, and there's article you can go to easily find it online. So this is some very, very brief data, and I don't have a fancy table like Thibaut has, but this is data I can, at this moment, I can find. So I put them into two categories, and that's, later you will see why I put them into two categories. The first bit is criminal deportation, and again, very, very not complete data. It's just roughly more than 1,000 people were deported from that time period. I hope in the future I can find better data, but that's data also based on other scholars' collection. So the more data we can find is actually from the National Immigration Administration, that is China's immigration department, if we put it that way. And also the wording you will see back to the National Immigration Administration, we start to use, I use removal. That is probably impacted because my background, legal practice background in Australia. I'm an accredited immigration law in Australia. I do practice immigration law, but it's in Australia. So in Australia, we have deportation and removal. And when I research on China, even though official interpretation for this part, actually they use repatriation, but I don't think that really captured the right nature of the legal action. So I choose to translate that part as a removal. So under that removal procedure, as you can see, there's more people, more aliens. When I say alien, let's just use relatively short interpretation is non-citizens or non-nationals. And from like we can just kind of estimate is that 1 year they will have roughly 50,000 people deported or removed. So I just heard our French colleague mentioned that's probably equivalent to French number, but thinking about China is a huge country, and but of course this is about aliens, not about the national citizens. But that's roughly kind of idea. You get a picture. For the criminal deportations, very small number. Let's use small number. And for the removal, probably bigger number, and China does remove people or expel people, aliens from Chinese territory. Very quickly move to the legal structure. Again, two parts, criminal and immigration. This is a legal basis. When we talk about the deportation, what's the legal basis to deport people? Just like in the US, may not be all the deportation is under the immigration law, maybe under other law. And in China, that's very much the case. And I also hear France seems quite similar. And we do have criminal law under criminal law Article 35. And the judge can, when they make a sentence, they can decide on either the judgment, the sentence, is deportation, Or they can say, okay, you serve in the jail for 15 years and we deport you. So the criminal deportation basically is made by the judgment of the judiciary. So in that sense, criminal justice will apply criminal deportation. This is probably quite different from many other countries, but maybe also similar to certain countries. The Chinese law, historically, we follow a lot of civil law system, like German law and French law, and that's kind of tradition. So you may see a little bit the trend of that. So under immigration law, and maybe I just move to this table, it's easier for you to see. I put them all the expulsion of aliens is the fourth category. Criminal one, we already discussed, based on criminal law, criminal deportation. We can call criminal deportation or criminal expulsion, but all other three bits is administrative. It's basically, it's no longer under the criminal justice system. It is back to national immigration administration. And within these three parts of the expulsion in China, and we can kind of put them into two categories. One is the people, aliens, they violate general immigration law, and then they will be removed. So we have particular Chinese words for that procedure. So basically, you can just see that's violation of immigration law. However, aliens or foreigners in China, they probably not just possibly violate immigration law, they may violate other laws. They may not reach to the level to criminal law because they'll go to another category. But if they violate, let's say, traffic law, and it's a contract law, or many other frauds, and so if they violate other law other than immigration law, if it's a minor violation, and maybe the government will say, you know, you violate the Chinese law, and you should leave, and you should leave within a certain period of time. Generally, it will be 15 days, and ask aliens to leave. That is the number three category. But if the violation is more serious, and that just reach to the level to go to administrative deportation. So I use the deportation and the expulsion differently. I use expulsion is more overarching to cover everything, but the deportation is either criminal deportation or administrative deportation. It's more serious deportation, but they also have other categories of the expulsion. That's really my basic structure and my presentation. They have lots of details. What's the legal basis? What's the ground they can do? Because this to understand the structure of the system, and we will know the procedures. Because my paper or my presentation is really about, yes, and every country as a sovereign state, they will have power or rights to expel aliens, but they never have unlimited rights to expel everyone or anyone. They should go through some procedure. But of course, what kind of procedure is the question? I did include in some international standard. I'm not repeating that. It's basically IRC draft articles and ICCPR. I should mention China has not ratified ICCPR. However, China did sign the treaty. So which means is China is not that free, can just say, you know, ICCPR, we have nothing to do with it, we can do whatever we want to do. In my article, of course, I try to argue certain part of the ICCPR may have already constituted customary international law. Not all scholars will agree with me, particularly in China, some scholars very much will not disagree with me. Article 13 has already become customary international law. For my purpose, of course, I want to have some international standard which has more force we should go to, and of course, whether it's really reached to the level customary international, we can argue. But basically, my argument is for criminal deportation, no matter how we comment on China's criminal justice, but because the criminal deportation will go through the procedure of the criminal justice, and they will have first instance, they have appeal rights, they will have counsel. So in terms of procedure, and criminal deportation probably is well protected compared with other procedures. The problem may lie within the administrative deportation and the removal procedure. And for the removal in Chinese legal system, they count as the administrative coercion. And for the deportation, administrative deportation, they count as international penalty. So because those belong to different legal system, and they actually apply for different procedures. But overall administrative expulsion. There's no judicial review. It's just full stop, no judicial review. And maybe in the removal, you have administrative reconsideration, which means you can go to another administrative higher level authority to review your case. Not necessarily the full merits review like Australia, but at least can reconsideration. But administrative deportation may not even have that level of reconsideration, but is arguably because language is still very weak. So I will just stop there because of the time concern. Yeah, thank you very much.
Thank you. Professor Marmo.
Here we go. Thank you so much. I'm going to start with acknowledging that this presentation was put together in the land of the Ghana people and who are the traditional custodians of a place we now refer to as the Adelaide Plains, and I would like to acknowledge that their sovereignty has never been ceded. My presentation is written through a critical criminology lens, and somehow I try to bring together some of the themes emerging from my fellow panelists. I'm very grateful to be here. Grateful to the Human Rights Program, to Professor Newman, and to Associate Professor Guo for bringing all of us together, and to my panelists, co-panelists for the wonderful presentations, and for all of you who came today. But I'm particularly grateful because I'm allowed to have a voice. And this is something that in 2025, crossing the US border should not happen. And so I really want to start from this because it's part of the tensions I want to refer to in my presentation. Why do I have to control and maintain a low key, control my voice and maintain a low key in the days before crossing the US border to join a panel on deportation? Why do I feel the anxiety? Why do I need to prepare for a potential interview at the immigration border? Why do I have to check what I posted on social media? Why do I have to say no to a TV interview for Australian ABC just the day before my flight, which on deportation, which really happened? So and I talked to my fellow colleagues, some of them also shared my concern coming from different countries. And in fact, fellow academic from Canada, a few days before this workshop, decided not to come physically, but to join us online. So why does it happen in 2025 for two academics working on the topic of deportation? And so to have a voice, I have to control my voice. And this is a paradox that we have to deal with. My presentation is limited to this identification of what deportation is as a non-citizen being removed from country because of breach of visa conditions and not having regular paper or the sans papiers is included into this, which usually we refer to this as administrative deportation. I think there are lots of unfair elements here. We don't have the time to touch upon, but some of my colleagues already touched upon, for example, Associate Professor Guo just now in China. And the other form of deportation is for those crimes committed. And we now, through this workshop, we're learning that different countries have got different practices here. So, for example, last night we learned that in Japan, if a non-citizen is sentenced to more than 3 years in jail, then they will be deported upon release from prison. In Australia, if there was ever a gold medal for mistreatment of non-nationals, perhaps Australia is a true contender, it means you only need a sentence of 12 months in prison. What does it mean? It means not just for a serious offense, they may incur to a sentence of 1 year or more, but also for cumulative sentences. So if you commit minor offenses, but altogether, they may be over 12 months. So we're not targeting the critical criminals, the serious offenders, the terrorists. We're really targeting normal non-citizens. And why do we do that? And then, scaringly so, we also now cancelling the visa and removing non-citizens for suspected criminal activities such as terrorists. And we learned yesterday Australia is not the only country doing that. So for me, any discussion about whether a deportation is administrative or criminal is a very interesting legal discussion, but it is not a very good way to frame what deportation is. Deportation remains inherently punitive, and we should not pass that without really being concerned about that. It's rooted in colonialism, and while it's presented to us as legal, is in fact very violent. What is more perhaps to the point here is that it's presented as if non-citizens can go through a bureaucratic process, but this process is a process that involves coercion. And because these people are already in the country, we are undoing belonging. And so we never should stop thinking that from this point of view. With my colleague and actually current lead of this Australian criminal deportation project, Professor Alison Gerard, who's sitting over there, and raise your hand because so you can go to her for any difficult question. Thank you very much. We see that very often we think about deportation as the Prime Minister of Australia or the President of the United States, so those people are in executive powers issuing some orders and then the person, the non-citizen being removed. But what we wanted to focus our attention was on what we are calling now the machinery of deportation, so all the other agencies involved. So there are those agencies at detection level, those agencies in the legal process, and those agencies in the custody level. So we're talking about so many agencies, different branches of the state, and yet they're all involved in this machinery, whether we want to admit it or not. And the more you dig in, the more you see they are very well connected, more than what comes to the surface. The other thing that we're learning in Australia, very much so, and now also we are learning from other countries, is that the legal process, the box in the middle, is been shrinking, if not bypassed, depending whether it's criminal, administrative deportation, but that one, the block in the middle, is disappearing. And this is an issue of serious concern. And so this is why I think we should not dismiss the colonial roots of our countries. And I have discussed this as a past-present continuum that persists these days. And also, we should not dismiss the way an American scholar, Juliet Stamps, described deportation regimes as crime migration. So basically, the blending of criminal law and migration law. We also shouldn't dismiss the danger that technology, the rising technology, is bringing into this space, because accelerating speed of removal, but also amplifying bias. So we already learned that international law does prohibit collective expulsion, and there are so many articles mentioned by my colleagues before. We also know that, unfortunately, states are continuously using deportation to exclude and control. And so what we are here to reflect, and the introduction to the special issue Sandra and I put together for the Griffin Law Review, is actually going to the core of this point, is that there is a growing divergence between national laws and international, supranational, regional laws. So what can we do about this divergence? That is one question. The other one to ask us in this phenomenon, in this divergent condition, is that if you look at the blue box there, is that we see a plurality, so an array of executive orders coming out in all countries. Australia is an example, US is another example. And these orders are used in their immediacy, so there is no time for the orders to be considered or checked or going through the courts. And so once a person is being deported, it will be very difficult to take this person back into the country. And so this is a phenomenon, another phenomenon that brings all of our countries together. This is happening right now, and is another point of relevance, another pattern that we need to keep our eyes on. So for me, really, this discussion is focusing on 3 points that I would like you to consider. Deportation is here to redetermining who stays, who can stay, and through state power. Sovereignty is reasserted through exclusion. And some of us in criminology would say is differential exclusion. So it's not a black and white situation. There are exceptions, but why? And human rights are increasingly being challenged. So the point to me is about resistance. Resistance from the point of the law, from the point of the judiciary, from the civil society, and from us academics. So we should question the normalization of deportation. We should resist the exclusionary logics that is being imposed on us. That requires organization on our part, obviously. And also, we should see how this reshaping of sovereignty is impacting justice. Thank you so much for your attention.
Thank you, Professor Marmo. There are a number of questions I could ask, but our time is fairly limited, and I would like to give priority to questions from the floor. If there are people who would like to raise their hand. Eva, please.
Can we pass the...
So thank you all so much for the panel and the lunch talk. It was very interesting. I have many questions, but I'll limit myself to 2 if that's okay. I have one specific short question for Professor Graff. It's about, you said that domestic law used to have more protection for deportation, and now it's limited to minors, if I understood correctly. Does that mean that there's no ex office judgment or like analysis of non-refoulement considerations and everything? Is there a standard giving of a return order and a removal order without, and then it's only like a post factum, you can appeal the order, but the administration, that's the French law?
I will answer to you, but I don't know if I answer right now or if you want to ask the other question.
Yes, please ask the other question.
Yeah, I'll edit. I'm sorry. So that was the first question. And the second question is, with now the Commission, in March, the European Union Commission published its proposal for the return regulation. And there's a lot going on there. But I was wondering, with the externalization and the fact that it is, in fact, I think also with beyond the EU, definitely in Australia as well, the ties of the person who is going to be deported and the country to which they're being deported, this externalization process is completely, like the return hubs is completely getting rid of that. And I was wondering how you look at that and how you think international human rights law or international law interacts with that externalization, because it's such a big way in which, especially in the EU, these administrative barriers, these pragmatic barriers to return are such a big thing that's being focused on. It, obviously, if you can just choose one place anywhere in the world where you can send everyone to, it might be very efficient to the EU, and we see that now being institutionalized. So I was wondering how you look at that. Thank you.
Thank you. Thank you for the question. So as to the first question, before this new law that was adopted in January 2024, you had several protections which were legislative protections. So these protections were in French law, and that was impossible for French authorities to adopt an obligation to leave French territory if you were in a category that was protected. So that would concern, for example, foreigners who were partners of French citizens, if you had French kids, etc., etc. Now they have decided in January 2024 to suppress this protection, which now exists only for minors. So the consequence of that is that there is no possibility for French authorities to adopt the obligation to leave the French territory. Of course, then there is a right to appeal this decision, but it's only ex post, which means that the decision has been adopted and you have to go to a judge, and the judge will check whether or not you have like family ties with France, which would then amount to the annulation of the obligation to leave French territory. So the protection still exists, but it is only applied by the judge. So which means that if you don't go to a judge, or if the judge wants to go a little bit quicker, or if you don't have a good lawyer, etc., then there is a chance that you will be deported, even though you have, for example, strong family ties with France, for example.
But I think that's a violation of ECHR baseline, right?
Not really, because as soon as you have a possibility to appeal to a judge, then it's difficult to say that under the ECHR there is an obligation for states to have legislative protection against deportation. The obligation is not to deport people if that would amount to a violation of Article 3 against torture or Article 8 regarding family life, but there is no obligation in the European Convention to have protection in the law of the state. So I think it's not a violation of the convention. And regarding the other question on externalization, very good question. I think that, once again, it's difficult to find in international human rights law an obligation for states not to deport people to other states where they have no specific connection. So which means that externalization is actually, I mean, it's actually why externalization is so important and is developing so much in EU law and practice. Everything is made to develop this externalization. So in the new Asylum and Migration Pact that will enter into force in 2026, everything is made for member states and for the EU to conclude treaties with third states, which will then make it possible to deport people to these states, but also to apply a specific asylum procedure, for example, because if it happened that foreigners transited through a third state that is considered as a safe country, then its application for asylum will be placed under a specific urgent procedure with less guarantees. So to answer quite quickly, I would say that it's difficult to find a way under international human rights law to contest these new policies of externalization. But of course we could discuss that for hours, and I would be pleased to do that, but in 2 minutes this is what I can say.
Thank you. Is there one other quick question that someone would like to ask? Yes, please.
Thank you all for your pivotal contributions. Fantastic work. Just a quick question on the policy and procedures playbook and the audit that goes with that. When you conduct your periodic review, whether it's yearly, annually, or semi-annually, using a committee or not, what are some of the best practices used that are subjective, not objective, if at all? If it is used, what are some of those subjective measures used that help ascertain reliability, procedural fairness, and consistency? The reason why I ask this question is because, for instance, when you look at international law, some constructs are not ratified across globally. For instance, dignity is ratified, the concept of dignity is only ratified in Mexico and Belgium as opposed to, say, the United States, but yet we use some element of subjectivity when we employ ethical decisions. So, long story short, I just wanted to know if subjectivity has been employed, and if it is, best practices used. Thank you.
Professor Sancin, we don't have very much time for an answer, so if you could give an example or give an abstract answer on the subject of subjectivity.
So the general position of international law, and including the Human Rights Committee, has been that these deportations have to be equitable and fair. So equity and fairness are the underlying tones of these procedures. And in practice, I would say some subjective elements in the decision-making might concern mostly the combination of various factors that would prevent the deportation or removal of a non-citizen or non-national from the state's party's territory. And how these factors, these criteria are presented very much depends on whether the author is represented or non-represented. And especially when the author is represented by very skilled lawyers or even some NGOs. And in that sense, the support of civil society organizations to be able to argue also on this more subjective side on how these certain guarantees are to be used in concrete situation of this particular petitioner are extremely important and might be decisive for the outcome of the decision.
Thank you very much. And my thanks to all of the panelists. Please join me in thanking them. Thank you. We are concluding.